well, and hope you're staying safe. So today we're looking at challenges in debt recovery. Those challenges that one can encounter when recovering a debt. Considering our laws and what our laws are saying. We have earlier talked about debt recovery in Nigeria. We looked at the unconventional methods people recover debts, and what the laws have said and what the cases. We went through some cases to know what the mind of the law is and what is the right way. So today, looking at the challenge of debt recovery. The first one is limitation of action. When I mean limitation of action, I mean statutory period after which a lawsuit or a prosecution cannot be brought to court. Under limitation of action, I look at statute of limitation. Statute of limitation is a law that bars a claim or bars claims after a specific period or a specified period, has elapsed. So statute of limitation is more like literally saying you can only bring forth your claims within this time frame. After this time frame, you can no longer bring your claim. So statute of limitation sets time limits for suing in civil cases. Yes, in civil cases based on when the claim, has accrued. Now, what is the essence of statute of limitation? Basically, what the statute of limitation has done or is doing is to ensure diligence in prosecution. Many people, let's say they're lazy or they just drag their feet. So what statute of limitation has done is to ensure that people are diligent. When there's a problem or you have a right of claim, a right of action, you should be able to be fast about it, institute the action, very fast rather than to wait and delay. So statute of limitation makes for diligent prosecution of known claims. The claims are being resolved in good time, where the evidence is still fresh, where the witnesses are available, and all of that. Just like the doctrine of lashes and acquiescence, statute of limitation, is designed to promote justice. Yes, by preventing surprise claims. Not someone will wake up after 20 years to remember what happened 20 years ago. You can't get witnesses. The evidence is no more there. So rather than you sleep on your rights, statute of limitation is saying we will not encourage you to sleep on your rights. You can't wake up after 15 years and start chasing something which you should have done 15 years ago. So where evidence is low, memories have faded, witnesses have disappeared, and you're waking up from the blues after 10 years, 15 years, 12 years to come and claim something you could have claimed 12 years ago or 10 years ago. So basically, what statute of limitation, aims to achieve is to make people to be diligent, to rise up when you need to rise up, rather than, let's say stand by and watch as time is going. You now wake up when you feel fit, or you didn't fit, to lay claims to things you should have laid claim many years ago. So statute of limitation removes the right of action, the right of enforcement, and the right to judicial relief. So this is one of the challenges of debt recovery. When someone is owed, you need to act fast. You need to don't just allow time to go. Don't just allow it to linger. Do what you're supposed to do within the right time, so that you'll not be caught up with the statute of limitation. There is prescribed period, for doing things. You can't just wake up whenever you want or whenever you feel and start doing things. There's prescribed time within which an action can be instituted. Now, for ordinary debt, becomes statute bar after 6 years. For ordinary statute bar after 6 years. Many people do not know this. Yeah, many people do not know this, and that is why many people, even though maybe someone is owing them, even the banks, customers are owing, they've not been able to retrieve or to recover this debt because of issue of statute. But once they institute an action, a criminal objection will be raised on issue of statute bar, and you see that it will be sustained, and it will be like, I do not get justice. Our courts are this, our courts are this. Maybe so they have bribed somebody, or people are just saying a whole lot, But because you didn't do the right thing where you're supposed to, you were supposed to do it, and the objection will be sustained. Now, so time begins to run when the cause of action accrues or have reason, or have a let's use the word accrued. Now, cause of action arises or accrues when the cause of action is complete. That is when the grieving party can begin to maintain an action. That is, cause of action accrues when the cause of action is complete. That means when the aggrieved party, that is the person who is being owed, can begin to maintain an action. It's very important. An aggrieved party does not have forever. You do not have limitless time to do anything you want. There is a specified, prescribed time for doing things. I said for ordinary debts, have 6 years within which to institute for the recovery of the debt. After the 6 years, it becomes statute barred. And when you now wake up from slumber and now go to court and they throw your matter out, don't need to complain. The judges are this, that one. But you slept on your right. And you slept on your right. Now, it's also important for you to know that time begins to run when demand. Someone is owing you. You must make a demand. Very important. You must make a demand. You must make a demand. So time begins to run when a demand has been made, and there must be proof of that demand. As an intelligent lawyer, as a smart lawyer, as a lawyer who knows what he or she is doing, it's important when people come to you, clients come to you, issue of debt, liquidated money demand and all of that. You do a letter of demand. You start from a letter of demand. After perfecting your brief, you then write to those people, to that person, asking for, demanding for the payment of that debt. So time begins to run when demand is made for the debt, and there must be proof of that demand. Now, for banks, for issue of loans, overdraft, time begins to run when the repayment is due and a demand is being made. When the repayment is due and a demand is being made. It's very important. Now also look at after a debt has become statute bar. Is it where it ends? What can one do? 6 years has passed, ordinary debt, and you just woke up like, how do I do this? How do I recover this debt? Yes, there is hope for you, but you have to understand what to do. Now, acknowledgement of debt revives a debt which has which is caught up by statute of limitation. What do I mean? Someone is owing you 500,000, 6 years has passed, and you write to this person to say, you are owing me so amount of money over 3 years or over 6 years, and you've not done. I've tried, I've been patient, and the person replies to you by acknowledging that debt. It has revived your right of action. You cannot institute, and that acknowledgement of debt waives or takes away the issue of a statute bar. Very important. Acknowledgement of debt. By the debtor, it helps to solve the issue of limitation of action. Another way too is where after you have demanded and the person now makes a part payment of the sum you just demanded. The person makes part payment. it has revived your right of action. You know, even if there's an objection as to the status of limitation, the mere fact the person has acknowledged it, the mere fact that the person has now made a part payment, it has revived your right of action, and you can proceed, in court, in your process of recovering the debt. You must not just any form of acknowledgement. The acknowledgement must be absolute and it must be unconditional. That is the terms or what the acknowledgement should look like. It must be absolute and it must be unconditional. So look at this case of Mercantile Bank against Fateco. It's a Mercantile Bank Nigeria Limited against Fateco. It's a 1998 matter, 3 Nigerian Weekly Law Report, part 540, 143 at 156. Mercantile Bank Nigeria Limited against Fateco, 1998, 3 Nigerian Weekly Law Report, part 540 at 156. Now, you must also note that a debt can, become due to when a demand is made orally too. But I advise that it should be made right, it should be made in writing, But you can still make it orally, or it could be in writing or by service of a writ of summons, So these are ways that a debt can become due. You make when a demand is made orally or in writing, so service of writ of summons. So in an action for recovery of debt, if no demand is made, the course of action or the course of action does not arise and no action can be commenced. Where no demand is being made, where you've not made any demand, you've not said give me back my money, you can't expect to rush to court to start filing processes, because there's no your right of action have not arisen. So it must note that demand is key in recovering of debt. So many people are caught up with this issue because they don't know when the right has arisen, even if it has arisen, maybe the issue of statute of limitation and all of that. But in all, demand is key. Now, so just like I earlier said, that if the demand is not made, the right of action has not arisen. So look at the case of Kolo against First Bank. It's a 2002 Federation Weekly Law Report. It's a part 116 at 1005. It's a Court of Appeal matter. You also note that even where parties are negotiating, it does not prevent time from running. People will say, we were been discussing on payment the last 3 years. We've been doing this. That you're negotiating, with the party in respect of how to pay, it does not stop time from running. It doesn't stop time from running. You must understand this fact. It doesn't stop time from running. So another challenge that we face in recovering of debt is unenforceable judgment. Now, you've utilized the summary judgment procedure, the undefended list procedure to get judgment. You've gotten judgment. Now, enforcement of judgment is another thing. It's a challenge because many people have judgments in their favor, but they have not been able to recover the judgment. Now, the unenforceable judgment is a challenge, where the debtor, who is now the creditor, does not have assets that you can sell to, to be able to realize the judgment. The debtor does not have enough money in the bank, but you've done the garnishee proceedings and there's no money in the bank. Even in some instances where the debtor just disappears, you can't even lay hold of. You go to their offer address, they're no more there. You don't even know how to start. It just relocates without any trace. So it happens. It does happen. So these are the challenges in debt recovery. These are the challenges. So another challenge is when the debtor files a counterclaim. It's a cross action. Like, yes, I'm owing you, but I'm owing you because you breached the terms of the contract, and now files a counterclaim. Start dragging it, and before you know it, trial, all these things, time is going. So these are challenges in debt recovery. Another challenge is issue of where there's a stay of execution after judgment has been gotten. The debtor now files an application for stay. In as much as there are conditions before the application for stay of execution can be met. There are conditions that must be met before it's started. You must know that these are also tactics that will be used to frustrate, claimant, who is being, or a person who is being owed. You also have to know that filing of a notice of appeal does not operate as stay. So, for someone who is filing the stay, it must be able to meet all those conditions before the courts can even listen and grant those the applications. So we've looked at the status of limitation. That's the status of look at status of limitation. That's limitation of action. We've looked at unenforceable judgments. We've looked at filing of a counterclaim, which is a cross action. We've looked at unenforceable judgment. Yes, we've looked at where filing of an application for stay of execution. These are those roadblocks. I call them roadblocks here. Problems or challenges in debt recovery. I just hope you'll be able to learn something today. You can also read it up. We're here to just support the legal education. It is our passion to see that someone is, gets knowledge. It's a thing of passion. Yeah, it's a thing of passion. And I just hope you enjoyed today's lecture. And I hope you're doing well. I hope you're striving to become better. I hope you're doing all you can to, be the best wherever you are. It's possible to be the best. It's possible to be the best. So I wish you well in your endeavor. I wish you well in whatever you find your hands doing. I wish you well in all you do. And I know that you'll turn out to be the best ever if you believe. So do have a nice time, and I hope you enjoyed the class. Share this video, click on the like button, and more so, do subscribe to the channel. Thank you, and do stay safe. Do take care of yourself. See you next time.